Good morning, everybody. Can everyone hear me? I will try using the microphone because my voice is a little bit on the soft side, but if it's bothersome to you, just let me know and I'll speak without it. But can everyone hear me okay? Okay.
At the moment.
I want to thank all of you for joining us this morning. It's terrific. And I have been doing this educational outreach for the last year, and I've had a chance to go to now all the district towns, which include Bloomfield, Windsor Locks, East Granby, and Suffield. And the turnouts have been excellent, and that makes me feel good because I view part of my role as your probate judge to be able to interact with you, answer questions, and help you navigate the probate court should you ever have to use it so that you feel more comfortable. Some people refer to the probate court as the people's court because most of our probate courts are located in our communities. We're the only judges who are elected. Other judges go through a judicial appointment process through the legislature, ultimately appointed by the governor. But the probate court judges are really your judges because you decide who you want and you actually elect them. And we have a little bit more latitude and flexibility to go out into the community and conduct seminars and educational events such as the one this morning. So I know it's a little early, so I thought I would start with a couple of warm-up jokes. I'm not the best joke teller, but let me start. There's a third grade teacher, and she is teaching mathematics, addition, subtraction, multiplication, and she decides after going over the materials to give a quiz to the kids in the class. And she hands out her sheets, and the sheet says the following. It says, Mr. Jones passed away, and he had an estate of $1 million. And he left that $1 million as follows. He left 25% to his wife. He left 25% to his children, and he had 5 children, but the total amount left to them was 25%. And unfortunately, one child had predeceased him, and that child had 3 children. And then the other 50%, 25%, he was leaving to about 10 different charities. And the other 25% he was putting in trust for some other relatives who were needy. And the teacher said, I want all of you to start with the $1 million bequest and figure out how much each person should be getting. So the children are there and they're writing away, and some of them have their calculators, and about a minute goes by and all the children are deep in thought. But John raises his hand, and the teacher says, is something the matter? And he says, I have the answer. And she's, bewildered. How could you possibly have the answer in a minute? And John says, I read this problem, and they need an attorney. And then joke number 2, just to warm things up here, is we'll use Mrs. Jones. She goes to the probate court because her husband had passed away. And she submits the paperwork, and the judge is looking at it, and he sees one of the expenses is a stone, and next to the stone is the number of $30,000. So the judge scratches his head, and he says to Mrs. Jones, I know that funerals cost a lot of money, but how could a stone for the grave cost $30,000. And she looks at him and she says, no, Judge, you have it wrong. I'm talking about the stone on the So, with that, let me start. And first, I hope to cover a lot of things as quickly as I can. And I would just ask you, I'm very open to questions. Feel free to raise your hand and interrupt me if you have anything. But at the end, when I finish, for those of you who have questions, I'll take them. And I know some people are hesitant to ask questions in public, so I have a little bit of time. I can wait here and try and talk to you individually and answer any specific questions you might have. So first of all, let's talk about what one of the most important functions of the probate court is, and that is decedent's estates. But it's not the only function. We actually have about 20 areas of jurisdiction. We do things like decedent's estates, we do guardianships for intellectually disabled children and adults, we do conservatorships, we do quarantines, we do termination of parental rights and visitation issues, and it goes on and on and on. We are a statutory court, which means that the only powers that we have are those that are delegated to us by the legislature. But every year the legislature finds new things that they give to the probate court. For instance, a few years ago, the issue came up in an apartment. If somebody passes away, and let's say they have a child that's living with them or an intellectually disabled person, how do you effectuate an eviction? And so it indicated that that has to go to the probate court, or if someone passes away and they leave their belongings and the landlord wants to remove the belongings, one of the options is to go to a probate court. So we keep picking up additional matters of jurisdiction that the probate courts have to deal with. We also belong to regional probate court districts for children's matters, and our probate district goes to Hartford. And so when I have a matter involving a child where there's a custody issue or guardianship, I send it to Hartford. As the referring judge, though, I sit on the case and I travel to Hartford. And the reason it goes to Hartford is that the Children's Regional Court has a group of staffers that are social workers. They call them family specialists. And they write up the reports, they investigate it, and the Department of Children and Youth Services, DCYF, they also have their social workers who are submitting reports. So when I have to make a decision regarding the placement of a child and who the child should live with, or a myriad of other issues that come before us, I have experts in the family specialists and social workers who are giving me reports, who are investigating it, going to the home, talking to the children, to the parents, and I have the best information available to make those decisions. Just to give you a quick little example, because it happened just last week, I had a case in Hartford where the parents and their minor child, who was about 13 years old, were living in Ohio, and they divorced, and the Ohio court gave custody to the father because the mother was having substance abuse issues. Father then relocated to this area in our district with the child, and mom stayed in Ohio. She had gone to Florida but then moved back to Ohio. Anyhow, Dad lived with his parents, the grandparents of this minor, and he had a relapse because he had some substance issues as well. So he's in therapy in a facility, so he's out of the house, and the grandparents came in under what was called a temporary custody application so that they could get custody of the child. So at the hearing, I had reports from all the social workers, and I had Dad who was there, who indicated he was in a program and he might be there for another 6 months. I had the grandparents who were beautiful people who wanted to take care of their granddaughter and were willing to do so. And the mother actually came in from Ohio, and she was not objecting to the grandparents having custody, but she was hoping that she would clean up her act. She had criminal charges pending against her and also some substance abuse issues. And what I did was I granted custody to the grandparents. I continued the matter for 6 months so that we could find out how the child was doing in school, find out how the dad had done in his rehabilitation, and how the mom did. And I said to everybody that I wish them well, because if all of them succeeded, the dad succeeded in rehabilitation, the mom succeeded in her rehabilitation, and the grandparents did a terrific job, and the child, who indicated she might want to return with her mom if her mom was able to care for her, I said, if all of you do well and succeed, you're going to make it very difficult for me, because then I have all these choices and I will have to decide what's in the best interest of the child. Nevertheless, that's my job, and I want all of you to succeed. And so that's how we ended the hearing, and we will continue in 6 months. That just gives you a flavor for some of the other things that the probate court does that you might not think of. So let's get back to first one of the main roles, which is a decedent's estate. So when somebody passes away, within 30 days, you're supposed to submit an application for probate so that the process begins. Now, there are two paths that one can take to begin probate. One is if there was a will, you submit the will, and the first thing to do is admit the will and appoint what we call an executor for a man and an executrix for a woman. And that person is a fiduciary, which has the legal responsibilities to probate the will, do all the accountings, make the distributions at the end of the probate period, and they are legally responsible for doing all these things. If, however, a person dies without a will, and we use the legal term intestate, then there's no will to probate, but we still open up an estate, and we appoint a fiduciary, but we call them an administrator or administratrix. And they do the same kinds of things that the executor would do under a will, except that there's no will. Now, obviously, one of the other big differences is that if you have a will, you're stating in your will what you want to happen to your assets, and you're stating who you want to be your fiduciary. And I'm going to go over a sample will with you in just a minute so you get a better feeling for what I'm talking about. But if you die intestate without a will, then your estate is distributed in accordance with state statute. So for instance, taking an easy example, we'll say a husband dies and he leaves a wife with 2 children. Okay, he has no will. So under the law, the wife gets the first $100,000, and then the balance of the estate is divided equally between the wife and the 2 children. And then it gets more complicated depending on other scenarios of who the heirs are. But again, if you don't have a will, you're leaving the distribution of your estate to the law, or to fate, if you will, because it may not be distributed the way you want it. So the main point that I'm trying to make is it is important for everybody to give some thought to how you want your assets and your estate distributed when you pass. And you know, unfortunately in life, it's something that awaits all of us, and there's no way around it. So I always tell people, and I tell my clients in my law office, that it's easier to do this planning before you get sick or something terrible happens, so that you can think about it with a clear head and make the choices that you think are important, than dealing with it when you're in the middle of a personal crisis. So after the appointments are made, just to get into a little detail and explain how it works, you have 60 days to file an inventory. The inventory is a list of all the assets, real estate, bank accounts, and so on. Now, one confusing area that I find people don't understand, and unfortunately many attorneys don't adequately explain to their clients, is that the only assets that go through your estate that are subject to the jurisdiction of the probate court are assets in your own name. So what does that mean? If I have a bank account with my wife and it's a joint account in survivorship, the assets in that bank account automatically go to her. There's no need for a court order because it's automatic. When I set up the account, I set it up in joint names in survivorship. If I have a life insurance policy and I name my wife as beneficiary, again, there's no involvement to the probate court because it already has a beneficiary clause. It's a contract, and it says who the beneficiary will be. If I have an annuity, or I have a piece of real estate where I list my wife as a joint owner in survivorship, or I should say she lists me as a joint owner in survivorship, then it goes to the survivor. So we're talking about joint bank accounts, we're talking about annuities, life insurance, real estate, car titles, and there are many other things. If they have a survivorship or paid on death, or they have a beneficiary designation, then that's how it goes, and it's not considered part of your estate. So what is your estate? Your estate is property that's solely in your name. It could be joint property that's not in survivorship, like my wife and I, let's say we have a house in joint names, but for whatever reason we did not put survivorship, then one half is mine. Or if I have a life insurance policy and for some reason I don't name a person, I name my estate, well, the money comes into my estate, it becomes part of the estate. So it's really solely owned property. However, also required as part of the probate court process is a succession tax return. And in the succession tax return, you have to list everything, whether it's joint or solely owned, because first of all, probate court fees are based upon your gross estate, whether or not it's, again, joint or solely owned. And also the federal tax, what they do is they carve out joint property that's passing to a spouse. So everything is listed, and then all the deductions, almost as difficult as a, your IRS tax return, they're carved out and taken into an account. But in terms of getting a court order, anything that passes by virtue of another document, whether it's a beneficiary or survivorship, is technically not probated by the court. So after the inventory is filed, the court is concurrently putting a notice in the newspaper announcing that someone has passed away, and anybody who has a claim against their estate can file it with the fiduciary, the executor, we'll say. And that period is 5 months long. It's 150 days, which in my opinion is way too long, and it's one of the reasons why estates take so long to probate, because you have to wait, that 5-month period. And then when you submit your tax return to the state, which is, understaffed, it can take a little longer for them to approve it, even if it's not taxable, and indicate, that there's no tax due. So anybody who submits a claim, then the executor has to decide, are those valid claims? And they submit a report to the court called a list of claims, which lists all the notice of claims that they receive and whether or not they agree they're valid or disagree. And at that point, the court may have a hearing to adjudicate those issues, or maybe there's no contest and every claim is valid and the executor indicates that they will make payment when the time is appropriate. Then when that is done and a tax return is completed, the next form is called a financial report. And this report connects all the dots. It shows all money coming in, what the initial inventory was, all expenses being paid out, and then what the proposed distribution is. So that I, as judge, can look at this report and I can check to make sure that all the money that was originally there was properly spent in terms of expenses. Any additional income that came in, let's say real estate was sold, was properly accounted for. And then I can compare the proposed distribution to what the will says, or if there's no will, what the law says, how it should be divided and distributed. And that's the oversight that the court provides to make sure that nobody misappropriates or does something illegal with somebody's estate. And then once that report is approved, then the fiduciary files an affidavit of closing just saying we complied with the court order and the money was distributed as indicated in the financial report. That whole process unfortunately takes about a year, mostly because of the waiting time for the creditors. And when we've had our judges' assemblies where we talk about, changes and things we like and dislike, I'm an advocate of reducing that to about 2 months' time to make a claim. I just think it's unfair to make people, at a time that's emotional to begin with, have to wait such a long period of time. In fact, I favor some laws that would streamline the whole probate process and make it a lot simpler. And in effect, we have done that to some extent. We have a process called streamlining. So for instance, if someone dies and you submit the will for approval and to open up the estate, and everybody signs a waiver saying that they don't want a hearing, I can streamline it without a hearing and just make the approval. Or if a motion is filed and everybody agrees with the request that's being asked, I can again streamline it. So that helps a great deal, and it removes some of the trauma of coming to court, although again, it's a little bit different than going to Superior Court or criminal court. It's a little less formal, and I know that I try and make it as comfortable as possible by, greeting people when they come in. It's not uncommon, for if someone wants to shake my hand, I'll shake their hand. I'll try and relax people because I have the flexibility to do that. But judges are all different. Some judges, they come in, they don't smile, they listen, and you're saying, oh, I'm so scared. What's going? And I am of the philosophy. I try and work with the people, make them feel comfortable and relaxed. So in a nutshell, and I'm leaving out quite a bit of detail of other issues that come before us in a decedent's estate, that is typically how it works. It can be a little complicated. There are issues sometimes. There's a fight over the will itself. Like just this week, I had a family come in and they presented a will, which, believe it or not, the decedent went on the internet and went on some legal site and downloaded and printed this format of a will where you check boxes and you fill in a blank and that kind of thing. But what did he forget to do? Even if I stretched it and I said, okay, the will is sufficient enough that it complies with Connecticut law, what did he forget to do? He never signed it. He didn't have the 2 witnesses that were required, and it was undated. So I said to the family, I would like to try and help you out, but the law is the law, and he didn't even sign the will. So in that case, I had to indicate that I was rejecting the will, and we would have to proceed with the probate estate as the intestate, dying without a will, which meant that it might go to different people than he had put in his will. But I didn't even have to get that far because the will was just so in violation of Connecticut law that I had no choice. I had another interesting one just a couple of weeks ago. It's a little complicated. This was an individual a man who died, and he lived with another man who was, his significant other. And in his will, he left everything to the significant other, and he left about 25% to a favorite charity of his. After he made the will, fast forward 20 years, Connecticut passes the law that allows same-sex marriages, and they get married. Now, the law in Connecticut says that if you marry, your existing will is revoked. So then the law was changed to indicate that you can express an intent not to revoke the will if you remarry. You can put that in the will, or you can express it through some other means. But the legislature carved out like a 20-year period that said if your will was made after this date but before this date, it's automatically revoked, and that will fell in that period of time. So I had no choice again but to reject that document because it was revoked by law. And again, I can't change the law. I have to comply with what I'm given. Well, that one had a very significant difference because the heir would be this gentleman, the significant other, because they were married and there were no children and no other family. So he would inherit, but the charity lost everything because, again, there's no will, so everything went to his husband. And it's up to the husband whether or not he wants to honor this charitable request. I tell you these stories, and I could tell you more, just to show the importance of making a will and making sure you consult with an attorney, don't use a form, and give thought to different options and contingencies so that you don't fall into the trap of having your will in violation of law and rejected. Now, I can tell you other stories about decedents' estates where the wills are proper and there are issues of undue influence. So I had a case about a year ago where there was a husband and wife, and one of the spouses passed, but before they did, one of the children took that parent into their home and divided the father and mother. And while that parent was living with the child, miraculously they changed their will. And the will left out the husband, left out the brother, just gave everything to the daughter who was caring. So of course, you know what happened, upon the death, the son comes in and says, how could I be disinherited? We had a lovely family, everybody liked one another, and all of a sudden, my sister comes and she takes the parent because she said, that they need extra care and she's willing to do it. And within the 2 or 3 months before they died, the will is changed and my sister's getting everything. So as you can imagine, that's being contested in probate court. And the question is, was there undue influence? Did the decedent have the mental capacity to know, what they were doing? What did the prior will have to say as evidence of what the intent was up until the point that they were relocated to the daughter's house? It happens all the time. It pains me to see some of the divisions in families and what people are doing. And maybe it's a sign of our economic times. People are just looking to, better themselves, and they take risks and do foolish things. But we're seeing it more and more. It's not always evident by redoing a will at the last moment. Sometimes it's an account. And you see that a year ago the account was $100,000 and now it's $20,000, and you're saying, well, where'd it go? I mean, I had an issue, this was about 6 months ago, where a mom who passed away was living with her daughter again, and during that period of time the daughter added onto her house a deck, a sunroom, an in-ground pool. So you know where the money went. And you can't really say that it was for the welfare of the mom, who was aged and pretty much immobile. And so that became a big issue. Just things happen. So when you review your wills with your family and with your lawyer, you want to select people that you have trust and faith in. There's no absolute in life. Things happen to people, but you have to use your best efforts to identify who you think would be best to administer your estate. Now, one point I want to make from estates, although we're not going to have time to get into much detail, sometimes there are reasons to create what we call a trust, where the funds that go into the will are then placed in a trust for the benefit of your beneficiaries. Now, why would people want to do a trust? Well, there are a couple of reasons. One is that people who are in the very upper income levels are attempting to reduce taxes, and there are ways to do that where you can divide your money among trusts, but it has to be irrevocable so that you can't get it back and it stays in the trust. And again, it's a very complex subject without time to go into all the details, but just to let you know that if any of you fall into a category like that, that's a legitimate reason to consider a trust. Connecticut has just increased its exclusion to $3.6 million, and the federal exclusion, I believe, is up. It jumped way up. I think it's to like 11 million. So I'm seeing a lot less of trusts being formed for tax purposes because the threshold is increased so high. But just keep in mind what the legislature and the government gives, the government can take. So in 5 years, the threshold could be changed by both the federal and the state governments. Another reason for trust is you may have a special circumstance where you have, let's say, a child that you feel is not particularly responsible. We'll just make something up. They like to gamble. And you're worried that if you leave them all the money, you know, they'll gamble it away. So you put it in trust and you select somebody to be the trustee that you have confidence in. And you provide, you know, that so much money can be given to the child every year. If there's a medical emergency or a health emergency, then they can get more than that yearly allotment. The beauty about trust is you can say whatever you want. There's no rules. You can give money in any way you want. You can limit it to just education and medical, and then distribute it at a certain age. Another reason for trust is that sometimes a person has no family around and they're worried that if they get sick, who will manage their funds? So they put it into trust now while they're living and designate somebody to be the trustee to administer it for their benefit while they're living, and then it has provisions upon their death who it would go to. Another area of trust, which unfortunately is becoming more common, are for people who have children with special needs. And there are what we call a special needs trust. And what this does is, let's just say you have a child or a grandchild that you want to provide for with special needs. You can set up a trust that supplements whatever assistance they get from government. And then upon their death, the money either has to go to reimburse the state for any state assistance, or it can stay, if you use what we call the Connecticut Partnership, which I encourage clients to use. You can choose to have it stay with them to help other people. The Connecticut Partnership is an agency that was approved by the legislature that pools different monies together of people who use their agency and invest it. They have social workers and they administer, so you don't have to worry about who the trustee is going to be because the partnership is the trustee. They invest, they protect the money, and they use their staff to determine what kinds of needs the person has and how the money should be spent for their welfare. And that's called the Connecticut Partnership. If you Google it, you can read a little bit about it. So those are some of the reasons for trust, which again, a trust can be what we call a living trust. You can set it up while you're alive and it can actually begin operating. Or it can be a testamentary trust where in your will indicates that it's going to pour the assets into the trust, and then the trust takes over upon your death. Before I go into another topic, yes?
What about revocable trusts?
Okay, good question. So a trust can be revocable, which means that I could set up a trust today, and if I change my mind or circumstances change that I don't need the trust any longer, I can revoke it and take the money back and put it into my own name again. However, once you die, your trust becomes irrevocable. You can't, or the family can't change it. So, you know, many people will say, it'll say on top, revocable trust of David Baram. It is revocable while I'm living, but once I die, it becomes irrevocable. A couple of quick things while I'm talking about estates. And I'm just going to describe these documents which I use in my law office to help acclimate you better to the importance of preparing your own documents. First is a basic will. And as I said before, a basic will, number one, will provide for the payment of your expenses, like funeral and medical expenses, and it will provide for payment of taxes, should any taxes be done. Then it also provides for personal property, your clothes, your effects, your furniture, appliances. Who do you want those items to go to? And sometimes it's different than the people that you're leaving, money to. And many times individuals want to specify, for instance, if there's an heirloom, a ring that was passed down from generation to generation, and you only want it to go to your daughter, not your sons, you can specify those kinds of things. Then we have what we call a residue paragraph, which says all the rest of my estate should be distributed as follows. And in a basic cookie cutter estate, spouse will leave to spouse, and then if one predeceases, it goes to the children equally. And if one child should unfortunately predecease, then if they have any children, their share goes to their children, who would be the grandchildren of the decedent. And sometimes there are specific bequests. It could be that you have a nephew that you've always loved and you want to show your affection, and you leave them $5,000, a specific bequest. Or there's a charity or institution that you want to leave a certain sum of money to, you can provide it. If you're a young family and you have children who are minors, you want to name a guardian in your will for the minor child, so that if you pass, the court who ultimately approves and appoints the guardian would know what your thoughts and expectations. And then you're naming an executor, which we spoke about earlier, to help probate the will. That's what I would call a simple will, a basic will. They can get more complex. In addition to that are health directives, which are also called advance directives, which are also called living wills. And what the health directive or living will does is it follows Connecticut law by saying, if a point in time comes where you can no longer make decisions on your own medical care, that you're appointing person A to be your health care agent, so that they can meet with the doctors and make decisions about your welfare, should you need surgery or medications or whatever. And again, this is only if you're incapable of making your own decisions. Connecticut also has 2 instances where you can decide to withhold life support systems. The first is if you're terminally ill, your physician indicates that you're terminally ill and you're going to pass in a short time. And the second instance is if you're in a vegetative state, like a coma, where you have no awareness of your surroundings. It allows you, just in those 2 instances, to say that you don't want to be resuscitated, you don't want to be put onto a respirator, a breathing machine, and you don't want food or nutrition tubes inserted in you. The theory being that you want nature to take its course. You don't want to be kept artificially alive on a machine. And this legislation, which is common in almost every state with variations, is a result of some of the stories I'm sure you've read about, where somebody is put on a machine, has tubes in them, and lives for 20 years, but they're a vegetable. And so what you decide to do with your living will or your healthcare directives is a very personal decision. Nobody can say it's right or wrong. And oftentimes, quite frankly, it's a religious decision. Some people have strong religious convictions about what they should or should not be able to do. That's something you need to discuss with your attorney so you understand what your options are, and then obviously you have to do some soul searching with your family to decide. Now, if you withhold these items, it still allows for pain medication to be dispensed. In addition to that, the living will or healthcare directive also now allows for you to make organ donations. Now, if you decide you don't want to make an organ donation, then we initial on a certain line. And if you do decide to make an organ donation, we initial on another line with some additional options. And those options are, is it for any organ, or do you want to limit it to certain organs? And then can it be done for any purpose such as transplant or research, or are you limiting it to another particular purpose? So it's a little complicated, and I always cringe when a client comes into my law office because this takes a lot of time to explain, and then to sign it, you have to go through it with them. It takes time and make sure they understand what they're signing. The point I want to leave you with is that the healthcare agents cover a lot of different things. And I'm not done yet. There's one more. The last thing is you can designate who you want to be conservator of your person. Now, conservator of your person is a position that helps you with all your personal needs. It could be employment, medical, hygiene, food, living arrangements, whatever it is. It's a person who is helping make your decisions for your personal well-being if you're incapable of doing it. And all you're doing is designating the conservator in this document because the court ultimately has to approve it. But the court will look at the living will to determine what was your intent, what was your preference. So you're appointing a medical agent, you're designating whether you want to be on a machine under the two conditions of being in a coma or being certified that you're terminally ill and will pass shortly, organ donations, and designation of conservator, all in this little document. The last stop, yes?
Can you explain to me the difference between involuntary and voluntary conservationship?
I'm going to get to that next.
Oh, okay.
If you just give me a couple more minutes.
All right.
The last document is what we call a power of attorney. Now, the legislature has a template that attorneys use, and I'm looking at what's called the short form. And the short form, you appoint somebody to be your agent to help you with about 10 different items that include real estate, stocks, banking, business transactions, insurance, litigation, that kind of thing. And it can only be used if you're incapable and the person is assuming responsibility for you. Or, you know, sometimes a young family, let's say the husband's job, he travels, you know, all over the world, and something comes up and his wife needs to go to the bank to withdraw something. If he has a power of attorney and named her as his agent, she can take this and do the business. So it's not just for emergencies or for, you know, seniors, it's for anybody. Now, a power of attorney terminates upon death. It's only good while you're living. So in a power of attorney, you're naming an agent. You can name a successor agent in case that person can't fulfill their responsibilities. And you're naming a conservator of your estate. Now, in the healthcare directives, I said you were appointing a conservator of your person. The power of attorney is a conservator of your estate. The difference being the estate is financial. Because if you look at the power of attorney, it's really about financial issues. Litigation, banking, claims, insurance, that kind of thing. So the conservator in this document is of the estate of, you know, your financial matters. Now, just one other quick comment about the power of attorney. The legislature, about 2 years ago, and you may know I served in the legislature for close to 10 years, and I was on a special committee that helped reform the power of attorney, and we created the option of what we call a long form power of attorney, which is twice as long as this, and it gets into a lot more complicated detail. I'm not going to go into the whole thing, but suffice to say, if you had financial needs where you wanted to give somebody the authority to make gifts so that you could qualify for Title 19, or you wanted to give them the power to transfer monies to a trust, or you wanted to allow them to decide how the money should be spent during your lifetime through gifting or transfers, the long form allows you to do it. It's a more complicated document that really addresses individuals who have, you know, more significant financial issues. It also, however, has an interesting paragraph in it about digital assets. I don't know how many of you navigate the computer, but you know, just about anything you do on a computer, you have passwords now, whether it's getting into your bank account, and if you're like me, you probably use the same password for everything, although they say not to do that. So if something happens to you, how does your executor get into these accounts? How do they find out all the things, you know, that you have in the computer? How do they terminate if you're on Facebook so that it doesn't go on in perpetuity? So this gives them the authority to get your passwords and utilize them for purposes of, you know, probating your estate and wrapping up your affairs. Now, you can take a paragraph and put it into a short form, or you can use the long form and delete everything else and just use the paragraphs that you want. So enough about decedents, estates, and wills, and that kind of thing. What I'd like to kind of conclude with, the other main topic I want to talk about, are conservatorships, going to your question. So in Connecticut, we have two kinds of conservatorships. One is voluntary and one is involuntary. And a voluntary one is, let's say any one of you at some time in your life, you know, you're becoming a little more forgetful, or you don't have the patience, or you just don't have the energy to deal with things. So you want to appoint voluntarily, of your choice, somebody who can take over the legal management of your affairs. And you can make a petition to the probate court and say, I'd like my daughter Susan to be my conservator. And when you're doing it voluntarily, the courts, you know, essentially approve it. They just make sure that you know what you're doing, the reasons why, and that the person you're appointing is willing to serve and is capable. Now, the other path is involuntary conservatorship, where for whatever reason you don't voluntarily want to make an appointment, or maybe your mental state is such that you no longer are able to even make that decision. So your daughter comes to the probate court and says, we're filing a petition for involuntary conservatorship, and we want, to appoint so-and-so as the conservator. Now, there are two kinds of conservatorships. One is of the person and one is of the estate, which you probably could figure out by when we looked at the health care and the power of attorney. We had two different types of conservators that we were designating as our choices, one for the estate, financial, one for the person, your personal affairs. So many conservatorships, the petitions apply for both the person and the estate, but not always. For instance, if somebody is in a convalescent home and the convalescent home is already taking care of everybody's needs, but they want to be conservator of the estate because they're applying for Title 19 and they have to make transfers, they may just apply for the estate. Or perhaps there's a situation where, let's say, Susan's mother is fine living in her apartment. She can drive, she can dress herself, she takes her medications, but she just can't deal with the finances. Or I can't tell you how many times you may be in disbelief, and I hope none of you were in this situation, particularly among seniors, where there are scams going on.
Oh, yeah.
People are calling and saying, I went overseas, I'm in England, and I have no money, my wallet was stolen, can you send me, $5,000? Or people will say, you won the lottery, and you have to give us, your social security number and this and that. And I get a lot of petitions from families where the parents, are being scammed. They've lost significant monies. And they need a conservator to control their estate, but on their personal matters, they may be fine. Now, the law forces the judge to, if we appoint a conservator, to make it what we call the least restrictive. So I have to make sure that I understand in a petition exactly what the person is capable of doing. And if that person can handle certain affairs, I have to allow that, and I should want to allow it, so that we avoid other tragedies where courts appoint conservators who take advantage of, the conserved and protected person and basically steal their money and their assets. So the conservatorships are under very strict control legislatively, so that we, number one, have to make sure that the person who's being conserved really needs it. And we, in an involuntary, the law requires a medical evaluation no later than 45 days before the hearing, so I can see what the medical diagnosis, do they have dementia, do they, what are their issues, bless you. And we have to also have testimony that proves to me by what we call clear and convincing evidence, which is a pretty significant standard, that this person cannot perform certain functions on their own. And then, if I decide that a conservatorship is appropriate, I then have to determine what is the least restrictive way to implement it. What kinds of things can this person do on their own? Now, even when a conservator is appointed, there is a list of things set forth in the statutes that require a conservator to come back to court for approval. To give you some simple ones. If you're a conservator and you wanted to relocate, let's say, your parent to a convalescent home, you need court approval. If you want to break a lease and move that person to another apartment, or remove them out of state because you're moving to Florida and you want them to go with you, you need court approval. If you want to put them on any kind of a psychotropic drug, you need approval. If you want to have them admitted to a psychiatric hospital or ward, you have to have a court hearing. So the legislature has taken things that they deem serious and drastic and required more court oversight to make sure that Susie just isn't putting her mom in a convalescent home and taking off with the money because she doesn't want to deal with the issue any longer. Things still happen. The system isn't perfect, but the law gives, you know, the probate courts the oversight and the responsibility to analyze these issues in a way that hopefully we can prevent some of the more egregious kinds of issues that arise. Now, for those of you who are interested in more information than what I have been able to convey, you can do two things. Number one, I've handed out to you a manila and a green booklet. These are written so that lay people can read them and understand them. And we have about 15 more pamphlets in the probate court that you can call the court or come to the court and just take these. They're free. Or if you're good at the computer, you can go on the probate court administration website, and all this information is on the website. And again, it covers another area, because I'm kind of out of time, people with intellectual disabilities, special needs. There's a pamphlet on that. There's another whole process of how you handle those things. So you can get your information. The probate court, in case you don't know, is in the Windsor Locks Town Hall, not very far from here. And it's really a very nice facility. And you can go there and just ask. We have 4 clerks in our office, and the clerks are instructed to be as helpful as they can. But one of the things the clerk cannot do is they can't give legal advice. They can explain a procedure, they can give you information, but they can't give you legal advice. And neither can I. And I have to tell you, you know, sometimes one of the dangers of doing something like this, and many probate judges will not do it, but I have a different philosophy, is that judges are afraid people will ask them for advice. You know, what do you think we should do? And especially since you're in my probate district, I wouldn't want to say something to you and then you come before me as judge and say, oh, Judge Baram, you were at East Granby and you said I could do this, and why are you saying I can't do it now? So we have to be careful, but I take the philosophy that it's our responsibility as judges to try and make the process understandable and to help educate people so that they're not afraid to use the probate court when it's necessary. And again, as I indicated, there are about 20 areas of jurisdiction that we have cognizance over. So it's not just people who pass away, it's not just conservatorships, but there are, you know, many areas that we get involved in. Some judges have districts that are in the geographic area of some of these psychiatric hospitals, like the Connecticut Valley Hospital, and those judges, I haven't had one yet, but they have to go into the facility and they have to order shock treatments and that kind of therapy, and there's a whole regulated process that you have to do it. There's only about 5 judges who are in those situations, so I'm hoping I never get into it, but you know, that's another area. I just got a petition in this week for a voluntary conservatorship from an inmate at the McDougall facility in Suffield, and I have not, in the year that I've been a judge, had application where I have to go to the prison. So I'm kind of looking forward to it, but my clerk has told me, he's scaring me, about what I have to go through and all this and that. When I was telling my wife last night, she wasn't very happy about the whole thing. But I'm kind of looking forward to it. But at any rate, that's part of the job. So I'm sure that there may be other things. So let me just ask, take a few minutes. Is there anything that I can answer for you that you're confused about? Or is there a topic that you would like to just chat about real quickly that I didn't bring up? Yes?
If there's an estate where there are assets in more than one state, if we're talking about property, for instance, real estate in Florida, does that fall under Florida, or does it come under the Connecticut, assuming the primary residence is in Connecticut?
Great question. So what would happen is if the primary residence is here, the estate would be opened in Connecticut, but we have no jurisdiction over property in another state, we'll say Florida. So you would then have to open up what's called an ancillary estate in Florida to probate so that the property would be distributed. And it could be vice versa. You move to Florida, you're a resident there now, but you kept real estate in Connecticut, so you're probating your estate in Florida, which may not even have probate, but you're then doing an ancillary estate in Connecticut. And you actually jogged my mind, because I really don't speak with an outline, I just kind of speak off the cuff, so while my sessions are a little bit different, but when we were talking about estates, I just wanted to mention there's also a thing called a short estate. If the assets are under $40,000 and there's no real estate, you can do an expedited short estate, which is actually you file an affidavit in lieu of probate, and the court can authorize you to distribute money, pay expenses, and it's a very quick process, but it has to be under $40,000. So I just call it the short estate. Yes?
There must be a cost to probate, but I have not heard any mention of it.
Right, so I'm going to interpret your question in the broadest way, and there's two costs to probate. One cost is to the consumer directly. Every time you file a petition, there is a fee, and there's a schedule of fees that the clerks, they'll check off, and they will send you a bill. And actually, the book I see that you're looking at, I think, has some of the fees associated with different petitions, and that's the clerk's job to go through it. Quite honestly, if you ask me what the fees are, I couldn't tell you. But they go through it, and they send out the invoices. The other fee, if you will, is that even though the probate courts charge, it doesn't pay for the system. And so the state of Connecticut has a stipend that they use to support the probate court system, just like they do the entire judicial system. If you go to Superior Court and you're starting a lawsuit, there's an entry fee, or if you have a criminal case, there's a fee also. The fees don't sustain the court systems. And you might say, well, why don't you just raise the fees? Because you run into the danger philosophically, if you raise the fees high enough, will it discourage people from using the courts, and will they just not do what they're supposed to do? So it's a balancing act, and just so that for those of you who might be a little bit more politically attuned and active, as you know, many candidates from both parties have recently advocated eliminating the Connecticut succession estate tax altogether, so that we can be more competitive and keep wealthier people in Connecticut, so they're not fleeing to other states that have no estate tax. And the probate assembly takes no position on that, but what we do say is that if you eliminate the estate tax and there's no funds coming in, somebody has to pay for the system. So the legislature either through its own allocation or through fees charged to users of the system, has to fund it, otherwise the system will break down. Now, even though we have been funded, it's been 5 years since any employee of the probate court system has received a raise. And being a relatively new judge, looking at the system more from the outside, it's very scary to see people who have been employed, who really know what they're doing, jumping ship, looking for other jobs because they can't get raises. If one of my clerks, who I really thought was spectacular, came to me and said, I can't afford to live on this salary any longer, I have to leave, I don't even have the option of offering that person an increase, because there is none. Okay. So interestingly, the judges, we're independent in the sense that for probate, we run our office. I hire, I fire, I'm in charge of the personnel, but I have no money. So it's very difficult, very difficult. I hope that answers. Yes?
Just so I'm clear on this, your very beginning statement, if you have a will and we'll say husband and wife, and everything is jointly owned, we still have to go to the probate court?
Great question. In that example, let's emphasize there's nothing in the person's name. Everything is jointly owned.
There'll be one exception that I'll ask you about afterwards.
Then you can, what we call, file the tax return, which still has to be filed even though there's no taxes, and it's called for tax purposes only, and you don't have to open up an estate. If you have a few assets, okay, but it's under 40, then you can do the expedited short estate, the short estate.
The other, along with that, what if you own motor vehicles, and what happens when the title is only in one person's name?
So the court will order.
The reason I say that are, our autos, one's owned by one person and one's owned by the other. The title is.
So in an estate, the court will order in the decree the transfer of the vehicle. And if it's a full estate, it will be part of the full estate. If it's a short estate, under $40,000, we still issue a decree which allows the person, the petitioner, to transfer vehicles and money. Again, the short estate, though, if you have real estate, doesn't apply because it's a different situation.
So just say that again, the first part, I mean, in the first case?
It's simply the court will issue a decree allowing you to transfer the car.
Okay.
Whether it's a long estate or the short estate, as I call it. Go you first, then you say.
Yeah. Probate is the reason that I don't own a house in Connecticut, because I took care of my mother. I moved her to Arizona, but she still owned a house here. So when she died, I didn't know everything that you're telling us, so I went into the probate court, or went into the office in town hall, and filed the papers, gave them all the information. It was 1.5 years. In the meantime, I never heard whether there was a hearing about anything. It was the only thing she owned is this house. I had to rent the house because I couldn't have it sitting empty. In the meantime, it was rented to drug dealers who put holes through the wall board, turned the basement into a crack house. It was covered, the floors were covered with glass and needles, and and I had to have that cleaned up. Because it was going through probate and I didn't hear anything for 1.5 years, I rented it again to somebody who wanted to rent it, and he was willing to clean everything up and repair everything. So I rented it to him for a very low rent, and he repaired the house. Eventually, when I finally insisted probate, I have to sell this house. I've got to get it sold. They called me back after about 3 weeks and said, okay, you can sell the house. And then something else happened that I don't understand. We sold the house for $99,000. It was worth more than that. But this man had done all the work, and he was very reliable. And so my sister and I agreed we would sell it to him for that price. So before we got the money, probate took their money. How did they do that? I thought that I would have to pay it. I mean, the whole thing,
Well,
this is why I don't want to do
I
this to
don't
my
know
kids.
your
So,
specific circumstances, but let me just answer a general question. When you have real estate, you know, there are special rules and it can be difficult. If a person dies with a will and the will has authority to sell real estate, you don't need the court approval. Although many times they will ask for the court approval because maybe there is a disagreement among the family about selling it, how much it should sell for, that kind of thing. But if the will provides authority, you don't need approval. If there is no will or the will does not have authority, then you have to come to the court. And if you come before me and there's a hearing, I'm going to look at evidence, what the fair market value is, what the contract is to sell it, what are the terms of the sale, because I have to make sure that all the beneficiaries of this estate are treated equally and that the home is sold, you know, for the market value. In terms of probate court fees, you know, the only thing I can say is that when a case comes in, the clerks log it and they bill it at a certain point. And we don't have access to an account. Somebody has to send us a check to pay it. We may say we're not going forward unless the fees are paid. And that may sound, you know, harsh, but understand we are audited by the state. So if the state audits our probate court and sees that we're not picking up fees, we're in trouble. I mean, we'll be reprimanded.
No, that isn't that is what I'm concerned about. I'm concerned about, shouldn't I have received a bill or asked me to pay it? I never got anything. They took the money before we got our money. My sister and I got it equally, like we were supposed to. In the will.
I'm just not sure how that could happen. Again, the only thing I could say is if you have an issue and you want to, if it's my court and you want to raise it to me at another time, I'll be happy to look into it.
Oh no, I don't. I mean, this is just why I won't own a house. I don't want to do this to my kids.
Okay. You had a question?
Yes, regarding the short estate, my brother quitclaimed his house to my sister and myself, and he also transferred his vehicle to me. And his assets certainly were under $40,000. Does that still qualify?
It should.
Okay.
It should. When somebody goes on Title 19, which is another topic that could be a whole morning by itself, there's a 5-year look back. So for that purpose, you know, if you were applying, they would look at any transfers within 5 years, and they could, you know, disqualify or penalize somebody for the value of those transfers. Mm-hmm. But in terms of probate, as long as there's no issue of undue influence or the family's upset about something, there should not be ordinarily a problem.
And is there a penalty for not filing within 30 days?
Filing a will? Not really.
And in the short form, a will's not required, is that correct?
Correct. So the danger, the danger is, in that situation, if there is a will, but it's under 40, you're filing what's called an affidavit in lieu.
Right.
You're not submitting the will. So if any of the other family or heirs feel that the money is not being distributed properly, they can file a petition in court, and we would then be able to hear the whole thing. But one of the dangers is if nobody complains or nobody files, you're sort of on your honor system that you're going to adhere to the wishes of the decedent.
Thank you.
And just to let you know, there's a whole theory called unsupervised wills that a number of states have adopted, and we're beginning to discuss it in Connecticut, which says to streamline and make this simple, if nobody's complaining about anything, why go through all this? Just file the will and you do it yourself. And only if somebody complains or only under certain circumstances would the court have jurisdiction. And that's being debated among the judges now. Eventually it will reach the legislature as to how can we simplify this process but balance the rights of people to make sure that there's still some oversight so that bad things don't happen. And that's many of the judge assembly sessions that I go to, that's the hot topic of discussion. How much should the process be liberalized? Well, I want to thank all of you. I actually have to be somewhere in a few minutes, so it was a delight being here. I get to Granby a lot for different functions, and it's nice seeing a new group of people. I wish you well, and if you want me back, let Kelly know. I make return visits. I'm always happy to come, or if you have a civic group and you'd like to invite a boring judge to come to speak for a few moments, I'm happy to do that too. But thank you very much.
Thank you.